So you've been arraigned previously, you understand the citation that you're charged with? Yes? Yes. State, is there an offer on this?
Your Honor, the state's recommendation with the court's permission is that the defendant pleads guilty with a sentence of credit for time served.
So the state has made an offer to you today. You now need to accept this offer. The offer is for you to plead guilty to this charge and be found guilty. You receive credit time served, and this case will be closed. If you do accept this negotiation, you're forever waiving your right to have a trial on this matter. You're waiving and giving up your 6 constitutional rights associated with trial. You're waiving your right to have an attorney represent you. You understand all of this?
I do. Is that provided that the charges that was brought in are dismissed?
Well, they're not dismissed. You'll be found guilty. You receive credit time served, and this case will be closed.
That was the charges that was brought in are
The only charges I have for you, sir, are these doing business without a license, soliciting products without having a license.
Okay, so those will be closed out today.
They'll be closed out today with conviction, yes, sir. You'll be waiving your right to trial, waiving your right to have an attorney represent you. You understand all of this? Knowing that you do not need to waive these rights, do you wish to accept this negotiations and waive your right to trial? As to the charge of doing business without a license, how do you wish to plead?
Guilty.
On or about the 24th day of May, 2018, while in Clark, Nevada, did you're selling products, produce and products without having a license to do so? Yes? Were you selling, peddling some products?
No contest.
All right. Adjudicate you guilty. The credit time served, case closed. Armando Andrade, 180-151-92X. He's present in custody, aided by the court interpreter.
Good morning, Your Honor. The court is present and in custody.
Morning, Your Honor. William Flynn for the state.
We have a prelim date scheduled for the 6th. This is on for bail here.
That is correct.
All right. Court will note that this will continue numerous times. The attorney was unavailable to be here, so that's why it's currently being held no bail at this time, pending this hearing. You may proceed. Defense.
Your Honor, we're requesting a $50,000 bail. And the reason mainly is because when he was arrested, he had no drugs on him. They went to his house, they found no drugs. I really don't even know why they arrested him based on the discovery that I have. Counsel was telling me that they have additional discovery that I haven't received. But based on what the court has now and what I have, I really don't see the grounds for sitting it down and in the realm of what the state wants. So with that, we are talking about the state as reflected in
State.
Yes, Your Honor. State's asking for $500,000 plus a source hearing and house.
Just out of here, guys. Have a seat.
And there's a number of reasons for that. First of all, the amount of drugs found in this case, we're talking about over 70 pounds of methamphetamine. The current complaint hasn't been amended to the total amount, but it's over 33,000 grams when you combine the stash location, the vehicle parked at the stash location. There's also a pound of cocaine found in those locations. This defendant is tied to that through a number of things. First, wire intercepts, this defendant having conversations with an individual in Mexico, essentially arranging for or agreeing to accept these, this methamphetamine brought into the country for distribution. The detectives and DEA agents then conducted surveillance in conjunction, of course, with those wire intercepts, identifying this defendant at those locations, the relevant locations, surveilling him and his runner, a second individual, going back and forth and conducting the activity of the organization. So the defendant is directly tied to these drugs, despite where he was found at the time that the search warrants were executed. Additionally, the defendant has an ICE detainer, so he is likely, if bail is posted, he is likely to be taken into ICE custody, which would indicate that he will not be present for future court appearances in this court. Whether voluntarily or not, he won't be here. Additionally, of course, with that amount of methamphetamine, this defendant is facing a life sentence. and there's an inherent risk of flight associated with that. That's the reason for the station.
Thanks.
Your Honor, regarding the ISO, I also practice in immigration. And the defendant is married to a U.S. citizen and is entitled to IS bond. Once he gets into their custody, we're gonna file a motion for a bond over there. So that's really not an issue. It will show up. Now, regarding the amount of drugs, what counsel did not tell the court is how it's connected to my client. He found the drugs in different locations that have absolutely nothing to do with my client. Their position is, well, we think he's connected because we have some recordings which the court doesn't have, I don't have. Okay, by the way, we have a trailing coming up, and I don't have what the state is alleging is that real evidence connecting my client to this case. But right now, I see nothing that connects him to any drugs. They went to his house, took some money, and when they didn't find what they were looking for, drugs, they threatened his wife with arrest and forced her to go to the Bank of America, withdraw money and give to them. And I don't even see that in the report. So there's a lot that's going on in this case that we don't know. But one thing that is clear, based on the discovery that I have, is the state has absolutely nothing connecting my client to any drugs. So I don't quite understand. If counsel has, as he's saying, if he has evidence that connects him, fine, I want that. The court would like to see it.
It's the first I heard about the forced security withdrawal.
Well, I don't know a lot of details about that, and I don't necessarily agree with, as you might imagine, counsel's characterization of that. I understand there were two different amounts seized. The one that's in the arrest, I think it's in the arrest report, about $38,000. Was cash proceeds located at, I believe, the defendant's residence. I haven't gone back through the money. There was an additional sum of money, I think it was another $40,000 or so, that when police questioned, when they served the search warrant on defendant's residence, questioned his wife about a bank account, and she stated that it's in her name, but none of that is her money, it's all his money. And they asked her to withdraw that and turn it over for forfeiture, which she did. Now, I don't know all the details. I
That
don't
was
know any
another
documentation.
40,000.
Yes, Your Honor.
Actually, Your Honor, to be exact, $42,900.
But that's a limited amount I know, and of course, that isn't really part of the criminal evidence in this case, so that's a
But
separate issue.
it does go towards the amount of money.
No, it does, but the $38,000 that Your Honor was already aware of is not what he's talking about.
Right. I'm just saying, so there's other sources now, other monies that were there. It's a significant amount of money. Anything further?
Your Honor, I just wanted to point out that the money, even the bank officials instructed my client not to hand over this money to the officer, because the officers were basically arguing amongst themselves. One of them said, we can't do this. And this one particular officer says, well, I don't care.
Well, that may be a separate issue about whether they had the right to seize the money. What the court is looking at is the ability for him to post any kind of bond, the ability for him to stay in the jurisdiction, and for him to come back to court, and for the safety of the community. Anything further from either side?
No, Your Honor.
That's it. Fine. The court will note one thing, a couple of things. I note that we have no risk of reoffending on this matter. Without a pre-trial risk assessment, I've got them at zeros. I got one misdemeanor conviction. I will also note there's an ICE detained on this matter. While he may be married to a U.S. citizen, he may be a resident. The court is fully aware that once a person is picked up in ICE, they can self-deport, which would mean that they would be deported back to the original country of their origins, and then we would lose them to the ICE, and we would not be able to get them back. And the bond that was posted will be forfeited because of a civil matter where they transported them back to another country. So that's a concern to the court. The amount of drugs that were found at a residence, which under the arrest report, Mr. Andrade did have contact. They indicated that previously he was 8555 East Lake Mead. That's where 8,359 grams of methamphetamine, 412 grams of cocaine were located. Further, at that residence, $38,000 was located. Mr. Andrade does have a vehicle, new vehicle which can be used for bond on this matter. given the amount of drugs, given the sentence that he's facing, taking into consideration all of the requirements the court is required to look at, his ability to return to court, his ability to post bond, his ability to flee the jurisdiction, the safety of the community, given that this amount of drugs are there, is significant to the community, and the safety of the community is paramount. The court is going to set bail at $250,000 with the condition of house arrest. And if he does post that, he must first be a source hearing on the $250,000 and be placed on house arrest. If he does go into, when he does post that and place on house arrest, he cannot self-deport. He must inform the ICE officials of the pending criminal matter. We have a prelim date schedule, I think, for the
Thursday. It's this week. I
this
believe.
Thursday.
Yes. Your Honor, if I may, if the state has additional discovery that I don't have, and they intend to use it.
Well, they have to provide it to you, yes.
Right, as I informed Mr. Aguirre just outside of court this morning, what additional I have and that I will get to him. But of course, as the court knows, Mr. Aguirre has been out of the country, and so we kept passing this matter, so I never had his actual attorney in the country. So I couldn't really give him anything.
And I understand that you were gone and you had some people step in. And the concern of the court, and I shared it with the state, was that we needed counsel here. And I wanted to set a prelim quickly because I didn't want him to wait. Now, he has a right to wait for prelim if you want to extend it. I have a problem with that.
The state, of course, has no objection to any continuation.
That's fine. In that case, we would request that it continue to next week.
Well,
If you've got a date.
That's fine.
What date is, I mean, you've got him scheduled, I'm assuming, for Thursday.
That's correct, but I can make anything happen as far as.
So I can extend it for another week, that'll give you additional time, that'll give you enough time to get all the discovery to you, because you've been out of jurisdiction for a while. I want you to be prepared, I want to make sure your client knows that he's waiving his right to have a prelim within 15 days, and I'll extend it another, I guess,
Yeah, no,
8 days, I guess, right? To next Thursday?
That's fine.
Next Thursday.
Yes. So next Thursday? All right, Mr. Andrade, you understand your attorney's request that we continue the preliminary hearing, which is currently set for September 6th. They want to continue that until 13th. You understand that? You're okay with me extending it out? So you're waiving your right to have a prelim within 15 days. We're just allowing you to extend it. You understand that, sir? You okay with that? All right.
Yes.
Vacate the prelim date of the 6th, reset it for the 13th. Return court date, that date will be?
September 13th, 9 a.m.
See you back here on that.
Thank you.
Benjamin Weeks, 17F06043X, Benjamin Weeks. Mr. Weeks is present in custody. Mr. Weeks, what is your true and correct name? And sir, do you have a copy of the criminal complaint that was filed against you? And sir, did you read it? And you understand the charges? Do you need me to read the charges to you on the court, sir? I do see, counsel.
Good morning, Your Honor. Sarah Hawkins out of the Clark County Public Defender's Office, bar number 13143. We just received an arrest report this morning. We're going to ask for a provisional appointment and a status check for confirmation of counsel tomorrow morning.
I currently got him set at no bail, so any objection to continue this matter for hearing on bail tomorrow?
Yeah, I will make the bail representations tomorrow, Judge.
All right, Mr. Weeks, you're entitled to have a bail hearing on this matter. You're entitled to bail on this matter. Currently, at this time, there is no bail, so I'm sorry. He's entitled to have a hearing regarding this to determine whether or not bail will be set on this matter.
Yes, sir.
Given these charges, I'm going to hold him no bail pending a bail hearing. Now, I can set it tomorrow for confirmation of counsel, and you can have a bail hearing tomorrow, or you want to set it?
You can do that, Your Honor. I just met him this morning. I'd just like to have the opportunity to sit down and learn something about his ties to the community, et cetera, before I make those
You
representations.
prepare tomorrow, or you want to file a written motion? It's up to you.
You know, I'd like to keep it on for tomorrow, just in case it's something we can address orally. If the district attorney objects and wants me to file something in writing, excuse me, Judge, you can do that too.
All right. So, Mr. Weeks, what I'm going to do is appoint the special public defenders,
Nope, just the Clark County
public
Public.
defenders to represent you in this matter. We're going to continue this matter for 1 day for confirmation of counsel. They're representing you at this time. If there's a conflict, we'll then address appointing counsel for you. You understand? You're currently being held no bail on this matter. You have a right to have a bail hearing on this matter to determine if a bail can be set in these cases. We'll set that hearing for tomorrow. That date will be?
September 5th, 8 a.m.
I'll see you back here on that date, sir.
Thank you.
Willie Charles Williams, 18F16235X. Mr. Williams is present in custody. Sir, what is your true correct name?
Buddy Charles Williams.
And sir, do you have a copy of the criminal complaint that was filed against you?
Yes, sir.
And sir, did you read it?
Yes, sir.
And you understand the charge?
Yes, sir.
Do you need to read the charges to open court, sir?
No, sir.
I do see you do qualify for the aid of the public defenders. Counsel?
Good morning, Your Honor. Sarah Hawkins out of the Clark County Public Defender's Office, bar number 13143 on his behalf. We're asking, the request is the same, Judge, provisional appointment until we can do a conflicts check. We've asked to put it on tomorrow, address bail orally if that's deemed appropriate. Otherwise, we can put that in writing in anticipation of a hearing.
All right, Mr. Williams, your attorneys requested continuation of this matter. I'm going to appoint the public defender to represent you in this matter. They're going to confirm that they can represent you. If they cannot, I'm going to appoint new counsel to represent you. You understand, sir?
Yes, sir.
You're currently being held no bail. Given these charges, the court has to hold a hearing regarding this matter to determine the bail in this case, all right? So I'm going to set that for tomorrow for hearing. That date will be,
September 5th, 8 a.m.
I'll see you back here on that date.
Thank you, Your Honor.
Trotter. Julius Trotter, 188F122768.
It's not coming yet.
So that matter. Alexander Gueva, Gonzalez Gueva, 188M15592X.
The motion to close the case, Mr. Chairman.
I apologize, Your Honor.
Alexander Gonzalez,
Thank you, Your Honor. My
motion
apologies.
closed.
I do have a receipt for LRS, I'm sorry, smart choices for the anger management. I believe the
State,
file,
you have the 50 hours with 500.
that's correct.
Is it closed today, State?
Yes.
Okay, so all requirements have been completed. This matter is dismissed. Return court date of September 19th is hereby vacated, and this case is closed.
Thank you, Your Honor.
Letitia White, 188M15087X. Letitia White, Ms. White is present in custody. Ma'am, what is your true correct name? And ma'am, do you have a copy of the criminal complaint that was filed against you?
Yes.
And did you read it?
Yes.
Did you understand the charges?
Yes.
Did you need to read the charges to your
No.
court? All right, Steve, is there an offer on this?
Yes, Your Honor, the state's recommendation with the court's permission is that the defendant plead guilty to the charge with a sentence of credit for time served.
Ms. White, the state has made an offer to you today. You now need to accept this offer. The offer is for you to plead guilty to this charge. If you found guilty, you receive credit time served and the case will be closed. You understand, though, if you accept this negotiation, you're forever waiving your right to have a trial on this matter. You're waiving your 6 constitutional rights associated with trial. You're given the right to have an attorney represent you. You're waiving the right to appeal this matter. Do you understand all of this?
Yes.
Knowing that you do not need to waive these rights, do you wish to accept this negotiations, or do you want to set this matter for trial?
I don't know. I guess.
You have a right to go to trial, man. You're not going to be punished for going to trial. The concern of the court, though, is that as a bench warrant was issued on this matter on July 24th, and you failed to show up to court. So based on that, I would set a bail on this matter. You have to reappear.
Okay, so it'll be like case closed. Is that what you're saying?
Case should be closed today. The conviction would stand. You would be found guilty of these charges.
Okay.
Would you like to accept the negotiations and waive your right to trial, or do you want to set this matter for trial?
I guess. Yeah. Yeah, I'll accept.
You understand by doing so, you're forever waiving your right to have a trial on this matter. You're waiving your right to have an attorney represent you. You're waiving your right to appeal this matter. And by pleading guilty, you're going to be found guilty of these charges. You understand?
Yeah.
And knowing all this, as to the charge of solicitation of prostitution, ma'am, how do you wish to plead?
No contest.
All right, stipulated the fact of circumstance, I just plead guilty to that, credit time served, case closed. Stephen Don Phillips, 12F1229PX. Mr. Phillips is present in custody. Sir, what is your true correct name?
Stephen Phillips.
Yes, sir, do you have a copy of the criminal complaint that was filed against you?
Yes, sir.
Yes, sir, did you read it?
Yes, sir.
And you understand the charge?
Yes, sir.
Do you need to read the charges to you open court, sir?
Yes, sir.
Now, do you see you qualified for the aid of the public defenders? I'm going to appoint the public defender representative in this matter. Do you have an offer on this?
Yes, Your Honor, this has been resolved.
All right, resolution is?
Sworn Mr. Phillips will be pleading guilty to an ITS misdemeanor, 15 days in CCDC with 6 days credit time served. You close out the case.
Correct, state?
Yes, Your Honor.
Mr. Phillips, sir, do you understand the negotiations set forth by your attorney and agreed to by the state?
Yes, sir.
And you agree with those negotiations?
Yes, sir.
You understand, in order for you to accept this negotiation, you're forever waiving your right to have a trial on this matter. You're waiving your 6 constitutional rights associated with trial. You have the right to appeal this matter. By pleading guilty to the misdemeanor charge, you will be found guilty of these charges. You understand?
Yes, sir.
Knowing all this, and after discussing this matter with your attorney, as to the next charge of misdemeanor, possession of dangerous drug, not to be reduced to interstate commerce, how do you wish to plead?
Guilty.
On or about the 3rd day of August, 2012, while in Clark County, Nevada, we were possessing of dangerous drugs with alprazolam, Yes, sir. I'll adjudicate you guilty of that, where you spend 15 days in the Clark County Detention Center with 6 days credit. I'll run that concurrent with any time you're currently serving, upon completion of 15 days, that'll close this case out. Alexis Hines, 17F1028X. Alexis Hines? Alexis Hines? Is that you, ma'am?
Yes.
All right. This is on for a bench warrant return. Court will note she pled guilty back on July 11th, 2017, with return court date October 10th, 2017. I had none of the requirements completed. Stated she stayed out of trouble.
Your Honor, it looks like the defendant picked up a battery charge on March 24th. And was in custody on that date, but we don't show him, and was in custody, I'm sorry, on July 16th, but we don't show anything since then.
This year.
Yes.
July 16th.
Yes.
Okay, thanks.
Your Honor, we understand this is an old case. None of the requirements have been done. She did pick up a new charge, it looks like, I don't know if anything happened with that charge. We'd be asking, instead of 30 days, we'd be asking for 15 days of waiting.
Your Honor, we'd ask the court to impose the sentence. That's the sentence that the defendant agreed to when she entered into these negotiations. She hasn't done any requirements. This case has been open for a long time.
All right, Ms. Hines, anything you want to say at this time?
No.
All right, you understand you're facing a 30-day suspended sentence on this matter, you understand?
Yes.
You understand previously you were released, you failed to show up initially back in July, there was a bench warrant was issued, when the county picked you up and pled guilty on that. You failed to show back up to court, there were numerous motions placed on counsel, you failed to show up for those motions. You understand this? All right, so taking into account the entire